As the panelists take their seats, let me explain to you, maybe share with you how our next 60 minutes can look like, and we hope looks like. We're going to be covering this topic through the 3 Ps. Each one of us on the panel are going to speak to the 3 Ps. Now, what are the 3 Ps? First, precision. Second, preparedness. Third, purposefulness. And you will appreciate why we are starting with the 3 Ps. Let me introduce the panelists very briefly. Their bios are available on CVent, so we won't go through it exhaustively. Starting on my immediate left or your right is Mr. Adam Roth from the BIS. To his left is Hermanus from ASMPT. And on extreme end is Vasu from Clifford Chance. Each of them bring a different perspective to the conversation we're going to have. Adam from the perspective of an enforcing agency. Hermanus being part of a global manufacturer of hardware and software for electronics and semiconductors. Vasu, who was previously with the Department of Justice in the US, having advised multinational corporations and individuals on a variety of matters, and now in legal practice. And myself being the beneficiary of their wisdom. So without further ado, let's start the session. Again, with the focus on how we are going to address the 3 Ps when it comes to identifying and addressing red flags. I'm going to try and get the slide to move, so just bear with me. On screen, to set the stage, are some of the business implications, consequences, outcomes that you end up having to struggle with sometimes. Whether it's advertent or inadvertent, we won't quite know. But each one of us, each one of you, where you are right now, do not desire for negative outcomes to present. One thing that uniformly resonates in each one of these cases that you see flagged is that there would have been a red flag. There would have been a moment in time where someone in any of these enterprises would have known that something was careening off course. It may have complicit managers, it may have had complicit junior officers, but more likely than not, all of them likely would have something that would have set out a point of inquiry. I can say that having been a prosecutor myself and having heard these cases as a judge before, that companies find themselves always having to approach risks, and all of a sudden things collapse. And now our panel is really trying to get us to think about how is it that we can avoid these implications? How is it that we can put profit before principles? So we've covered this. If you think that compliance is expensive, the price of non-compliance is far more. We recognize that the reputation of our industry, the reputation of our business, and fundamentally the reputation of our countries is dear to us. And so having to have that compliance mindset is not just about saying no, it's about really trying to thrive by doing right. So with that, I'm going to allow our first panelist, Adam, to set the stage for us from his lens about some of what he has noticed, which helps us frame our discussion before we all unpack this together. Now, you would appreciate that there's only going to be 2 more slides, and you are not going to have death by PowerPoint. So what we plan to do in this session is, given how experienced all of you are, we want this to be as interactive as possible. I'm going to try my very best to ask all the questions that Vasu will probably charge out thousands of dollars an hour for, and Adam would probably be loath to have to deal with, and Hermanus having to confront this inside his business. We want to ask all that hard questions so that you can walk away today knowing, yes, that's an actionable piece of insight. That's something I wouldn't want to do. That's something I can now do. So without further ado, let's put our hands together to welcome Adam Roth. You may have to point it towards the screen.
Yeah, it looks like. All right, thank you everybody for being here. I think as Mr. Peach said, I'm trying to fight the blood to keep it in my head, but I think we'll be okay for this discussion. So, wanted to go through 2 different scenarios, and perhaps you can help us as I'm going through it to sort of think about what you may have done differently or where you think the red flags in this analysis, would have presented themselves. So in this first instance, we have a U.S. exporter applies for an export license. This is for a thermal augmentation device, which I believe is a device that goes over night vision equipment, helps add thermal imaging to it. So it required an export license based on the commodity, and a license was approved. So this license said it was for the Ministry of Defense for Latvia. And we did some open source research. I think that's searching on the internet through whatever search engine you choose to use. And in this case, the address on the export license matched the Latvian Ministry of Defense address. So it's looking pretty good at that point. The shipment is shipped. And when we follow up with the Ministry of Defense in Latvia, they say that they can't locate the shipment, and they actually don't recall ever ordering it, so it's not a great sign. We end up asking the company, the exporter, for the shipping documents, and the address that they shipped to was not the address that was on the export license application. In fact, it comes back to a chalet that you can rent. There's a U.S. travel site, booking.com, getting some free advertising, whether they want it or not. But they have this chalet, which does not appear to match the end user for which the license was approved. So, from our perspective, the glaring red flag here would have been to the exporter to say, hey, the ship to address does not match the address that we were presented with when the license was approved. Perhaps amongst some other things like, is the Ministry of Defense only needing one thermal augmentation device? But other things that you can sort of think about, if you were in this scenario. For our second example, and I'll give a little bit of insight here, maybe some secret enforcement, information here. But one of the things that I look for when I'm trying to target potential diversion worldwide is to look for exports coming from the same supplier. So what I find is that the bad guys often find a good supplier and they want to keep going to that company even after they've been identified. So we may shut down a foreign diverter, and they kind of come back and change their name. It reminds me of like a TV show. They put on like a fake mustache and a nose, and they're like, "Hey, I need the same items. I'm not the company that was previously ordering these for diversion." So what we'll do is look at the U.S. supplier and say, "Okay, they're not shipping to company ABC anymore because we've identified ABC as the diverter. Where are they shipping to now?" And then I see that the same U.S. supplier is now shipping to, in this instance, to a new company in Malaysia that they have never shipped to before. And this was U.S. origin aircraft parts. So, okay, we're looking at this company in Malaysia. Again, open source internet research. Doesn't appear that they have any real connections to the aircraft industry, but we'll have to look into it further. When we speak with the U.S. supplier, they said that these parts are for a client in Estonia. So, I put the map up there for your own sort of awareness. If you didn't know how far Estonia was from Malaysia, it's not a typical transit point. I think there's shorter ways that you could get to Estonia versus going to Southeast Asia. So that's certainly a red flag. Later on, we actually conducted a post-shipment verification with the company in Malaysia. I think actually Mike Burnett, he did it himself. And this company said that they have nothing to say, they've gone out of business, and everything went to Estonia. But we actually continue to see that they were trying to procure U.S. parts from the same suppliers. So not typical behavior of a company that's gone out of business. And ultimately, we discovered that these items were not going to Estonia. They were, in fact, going to Iran. So, all these things lead to investigations, potentially on the supplier, certainly on the diverter, and there were red flags all along the way. And that's sort of the topic here today is as industry, what are things that you should be on the lookout for? When do you address it? What is your due diligence requirements, and sort of what makes sense for your industry and your products? So just wanted to give these to maybe kick off some of the discussion, and I'll turn it back over.
Thank you, Adam. So now you have seen what might have been our final slide. And I want to leave this map there for us, and as we get into this discussion that we hope would be as robust as it can be, let's start off with the question that typically I know we hear, which is how much due diligence is required. Amongst the folks we have people from multiple sectors. We even have some who are resellers who will just have an impression that ultimately I'm selling it off. I'm not fundamentally responsible for anything much more. So let's start off there. How much due diligence is required? So maybe, Adam, if you don't mind, we start with the regulator.
So I don't know that there is a perfect answer to that, right? It's, I think, enough due diligence that you feel comfortable with the transaction. So certain red flags are going to trigger additional due diligence. If it's a major corporation known worldwide, the due diligence level, I would say, would be a little bit lower. But this is a first-time importer that you've never dealt with before, and they're asking for many parts. They don't seem to know much about the industry. They suddenly need 50 pieces of electronics that are used on UAVs, and they don't really have a good explanation. They're not a UAV producing company. But those are big red flags that require additional due diligence versus shipping internet routers to a major tech corporation, lower level of due diligence. But again, it's I think a case-by-case basis. It's not really a perfect answer for that.
Sounds like you're talking about proportionality and depending the size and background.
That's correct.
So there's no perfect answers in art and science. So maybe then this lets us pivot off to Hermanus, who is on the ground. Hermanus, what would be an example that you may have that comes to your mind about you watching how due diligence practices had informed the decision to trade or to move away from the transaction?
I would echo what Adam just said. Basically, in trade compliance, we will focus on the product, the end use, and destination. So in terms of the due diligence, the red flags that will surface depends on the types of customers. And I think we talk about distributors, resellers. That would be red flag number one, that we need to make sure that they are legitimate. And in terms of the product, if the product is low tech, let's say, is probably less risky, so you may not need to do certain checks because of that. And end use, if it is aerospace or something, then of course you need to dig deeper, especially if it is a transaction with the distributor. What we will do is basically to dig deep to make sure that the end user or the customer of the distributor is legitimate. They are not themselves distributors. So it depends on what you find as you dig, as you peel the onions, right?
So maybe if I can be provocative, what do you mean by peel the onion and to look for legitimacy? Would you have an example of how you have peeled the onion, so to speak?
Right. I can give you an example of, let's say, a distributor transaction. So the first layer is we need to do due diligence on the distributor, whether they have signed some kind of agreement with the company, and then we look at the size and the company, their customer profiles, and then whether and when they order products from the company, whether it fits in with their end users, business profile, and location to the end users. So we clear that level. In one case, we found that even the distributor's customer is themselves a distributor. Okay, so we had to ask tough questions. Are you really sure that you are the end user? So, and finally, they admitted that, okay, actually it's not. It's another country in Central Asia. At which time then we decided, okay, that's enough red flag, and we basically stopped the transaction. So that's the ultimate, that we really have to stop the transaction.
Okay, so now maybe it comes a chance for me to ask Vasu. Vasu, as I mentioned to you, was formerly with the Department of Justice in the US. So I have one regulator, one former regulator, and right now, Vasu, how would that sound to you? If you end up having to ever negotiate on behalf of a client who says that they have done their best, and Hermanus gave you some examples of what they have done or can do. You've heard Adam saying that, requires some proportionality. What have you seen that has allowed you to convincingly speak to a regulator to say, my client has done these? Isn't that enough?
That's a great question. I think it's a continuous chain that we're talking about right here. And I think what everyone is saying, spot on. I think Adam essentially is saying what a lawyer would say is depends, right? Your due diligence depends on what you're selling and what you're doing. And I think from my perspective, though, when I get involved, and in Adam's example, when he talked about the goods were being sold from the US to a distributor in Malaysia, it was going to Estonia, they stopped it once, supplier sells it again. The people that I would represent are going to be the suppliers in the US potentially. And so when I go into their offices, because Adam's already been there, asked questions, they're going to say to me, what do we do? First thing I'm going to say is, where is your due diligence policy? And they're going to say, here it is. And I'm going to say, how did you get to this due diligence policy? Did you conduct a risk assessment? Did you understand what the risks were and how we could end up here? And if they say, what's a risk assessment? That's going to be hard. That's going to make my life very difficult to negotiate with the government. If they say, oh, of course, Vasu, yes, we did a risk assessment. We know what's been happening around us. We understand how sensitive our goods are. Here's the things we did to ensure that we don't get in this situation. And what I want to be able to show, Adam, is that we have a policy. It was a risk-assessed policy, and we followed the policy all along the way. And here, and this is, what we want to do is, I don't want to take down the whole company. I represent the company. I want to protect your company. Usually what will happen is that there'll usually be a rogue employee who decided that despite all these policies that we developed, despite all the money and resources we spent to do this right, someone wanted to make a quick sale. And so they violated the policy. So what I'm going to try to do is say, hey, Adam, listen, this is all what we did, but here's what I did. I conducted an internal investigation for the company, and I figured out exactly what happened. And here's what happened. And then I think that would be something that Adam and his team are not just going to walk away and be like, all right, thanks, Vasu, that sounds great. We'll prosecute this guy. They'll kick the tires on that risk assessment. They'll kick the tires on that compliance policy to ensure it was appropriate. And so everything that Hermanus was talking about, they're going to do with the supplier, I want records of all of that. I need all that recorded. I need forms, I need signatures, I need emails, because no one's going to take our word for it that it happened.
Sounds like all about the preservation of evidence, to be making sure that you can prove
Yes.
that indeed you have your plan in place.
And you used to be a judge, so you know how it works, but Adam is the judge, jury, executioner. And so you want to be able to, in the US system, it's more of a negotiation, because again, they're doing this outreach right now to all of you, because they want it to work. They don't want to just penalize folks. Adam can correct me if I'm wrong here.
No, that's accurate. We want to prevent diversion. That's certainly the preference. We're not trying to trap people or trick you into something. It's prevent diversion to the...
So maybe then let's try and focus on something else. Now, just where we are right now, we've heard three perspectives, and remember the three Ps. Each one of them is going to be approaching the message, happens to be in that order. The one thing that I've noticed, now I teach compliance and risk management, I've been in the industry, and often the lawyers will tell their clients you need to have appropriate contractual provisions that allow for you to deal with bad actors. So contractual provisions is the next area that I want to jump into briefly, because sanctions clauses are typically in agreements. And can I see a show of hands here? How many of you in the audience have dealt with the sanctions clause? Can I see a show of hands? The rest of you haven't had to deal with a sanctions clause. That's great. So maybe I'll just give you in about 60 seconds a case, which is the most recent in Southeast Asia. It came out of the Singapore Supreme Court. The decision was JP Morgan versus Quivera. How this happened was you had JP Morgan that ultimately was sued and had to pay damages. JP Morgan had relied on a sanctions clause. Why did it rely on the sanctions clause? Facts as follows. Between contracting parties that had a letter of credit exchanged between themselves, the buyer supplied the seller with an item, and upon the completion of that sale, the seller is supposed to receive the money. The money was to have been paid by the bank, JP Morgan. The supply had completed successfully, and the money was due to be paid, but JP Morgan didn't want to pay the money. Why? JP Morgan noted that the vessel that was responsible for the carriage of the item, at one point in its life, the ultimate beneficial owner was Syrian. And when they realized that, they didn't want to pay on the LC because they didn't want to find themselves to be in breach paying to a designated party. How does that impact you is the question that I'm about to pose to the panel. Because you had an entity that had looked at red flags, had flagged the vessel as having been a vessel of concern, but it made the mistake because at some point in time, the vessel was no longer Syrian-owned. The beneficial ownership had changed. And now this gets me ahead to some of the questions that I've seen in coming from the audience. How do you deal with vessel change and ownership? So my question that I want to discuss with the panel is this. As industry members here rely on sanctions clauses and they go back to their data to make an assessment as to whether there was a red flag, what would happen if they rely on all information which wasn't updated and turns up that it was inaccurate, and then they're ending up having to decide, do we still trade or not trade? So I wanted to ask your perspectives, because ultimately the amount involved in this case was not very large. So maybe we start off with Vasu this time. Vasu, how would you feel if Hermanus told you that I did the due diligence, I had concerns because my master list revealed that this entity is a vessel of concern to me, we don't want to trade with them. What would your reactions be?
So in your example now, we've moved away from a violation. So your diligence was bad. And I think one lesson to take away from that is that this is a very, very fluid space. I mean, things are happening as we speak across the spectrum, from OFAC, from sanctions, from export controls, from CFIUS reviews. Things are changing. There was an announcement that went out this morning, for a reverse CFIUS program. So things are constantly changing. So it's incumbent on your business to track the right information, sign up to the right sources to ensure that your lists are accurate. And every morning, essentially, that can change. But again, you have to be reasonable. You cannot be, right, all of us we're not in the business of compliance. We're in the business of whatever our company sells. And so I think that's a very important thing to realize. But realize that when you don't do the compliance right, non-compliance, as we've said now, I think I've heard it the fourth time, is really expensive. So in this instance, I think it's an unfortunate situation. And I think if you ask that bank whether they felt that was the right thing to do, err on the side of caution, I think they might say, despite the litigation they faced in the Singapore courts, had they got it wrong on the other side and had to face US regulators, that might have been a very expensive process. But I think that is a outlier case, which is important because it's a reality. But I think for what the export control regulations are designed to do, following the list on a regular basis, ensuring you're up to date on your trainings, on your reviews of your list is really important.
Perfect. So that means you've got to map your risks in a both direct and indirect. And now I want to ask Adam and Hermanus, in this judgment which I just mentioned, the judges had specifically had a paragraph written where they say, quote unquote, there are red flags and there are red flags. So, if that's fun, isn't it? There are red flags and there are red flags. You know what we mean? Inverted commas. So, asking Hermanus and Adam, would you maybe with your experience just give us an example of two really striking red flags that you wish for us here to know and take away with us? Whoever wishes to go for it, maybe Hermanus first. Two red flags that you know that you have seen, that you want here everyone not to make that mistake.
The first one that comes to mind is really shipments to Central Asia because of the Ukraine-Russian war. So to me, that's the first red flag. And following that, of course, whether the equipment that they're purchasing or the product they're purchasing is relevant for the country, for the buyer itself. So that's the first one. The second one I would say is sometimes the Incoterms, if it's X-Works, for example, that indicates that they may want to take control of the logistics, and after we deliver to them at our dock, then they can basically do what they want to do. And if the equipment that you are selling is sensitive, then it's another big red flag.
I'm not sure how many of you are familiar with trade compliance parlance on Incoterms, but there's XW and then there's DDP. I'm happy for Hermanus for you to kind of tell us what would be the areas that you think to be challenging, and or not say challenging, that you may strike you as an odd situation. Would you care to just elaborate on some of the Incoterms that maybe are more familiar to you?
Yeah, as I said, X-Works to me is suspicious. Unless it's domestic, in which case Incoterm doesn't apply anyway. But if you could at least take the C term, if not the D term, where the D term will allow you to control to the destination. So hopefully your LSP, your logistics service provider, is not under the secret payment of the end user. So.
And this goes back to some of the things they've been hearing, trade-based money laundering and proliferation finance, and knowing the customer and knowing the destination. So the use of Incoterms strategically is a benefit. Adam, how about you? Is there any two red flags that you've seen that you can tell us?
I think sort of building on that, and I don't think that just being in a certain part of the world is necessarily, implies that you're doing anything wrong. But when you put it together with other potential red flags, so after the spring of 2022, we noticed a enormous shift in the export of tier 1 microelectronics, such as those found in items over to my left of the room. And these were going to Kazakhstan. Particularly, it was I think 4,000% increase, which is certainly a notable increase. I stopped thinking about percentages when it goes over 100, but this was 4,000% increase, and it was going to primarily like two companies. So two companies that seemed to suddenly be formed or incorporated in 2022 are now ordering millions of dollars worth of microelectronics. That is an enormous red flag. So new companies, that's one thing. New company ordering a lot of merchandise, that's a compounding red flag on that. And then is it in an area where diversion may occur? Particularly sort of based on the particular diversion at hand. So if it's diversion to Russia, is it a place that has proximity to Russia? Is it diversion to Iran? Again, or common transit points to Iran. So those are big red flags. And then the other thing that I look at often, many companies ask for end user statements, but they don't really ever read what's written on the end user statement. So sometimes I've seen end user statements where they'll ask how long have you, who's the intended end user, how long have you been in business, and people will sort of fill in whatever they fill in, but nobody checks that. So I get a copy of it, and it says this company's been in business for 4 years, and I do a quick search, just open source search on their website, and it shows their website was created 6 months ago, and it's hosted in Russia. So that's not a, and that took me like 5 minutes of due diligence to do. So I think those are some of the big red flags that I've been seeing.
Absolutely. I think Google is your friend, and using it selectively, using the time machine function to it, really allows one to make very quick assessments, and due diligence doesn't have to be a deeply complex process if you do it smart, I suppose.
Can I add one more? I also use Google Earth. In my previous life, I've seen the ship to address is somebody's garage. And another case is just an open field, without any buildings. So Google Earth is quite a useful tool.
That's a really helpful reminder, because once you have the address and you can check it, it really may set off a very interesting chain of inquiry. Let me maybe use this chance to, before we pivot to another area that I wanted to cover, there's a question that came up from the floor, which is specific to the due diligence steps that a customer should take when the due diligence steps that the client should take when the customer is on the trade integrity project list. Aside from a list, the question really asks, what steps would satisfy the authority? So this question to Adam first, and then I would love to know what Vasu thinks about that answer too, because his clients may say, you must be crazy to do that. You think money grows on trees? I can't do this all the time. So what would be?
Yeah, so maybe what we also refer to as a red flag list. A lot of these companies are based on publicly available trade data showing that they re-exported, at least from our perspective, U.S. origin items or items subject to our controls to an end user. Most recently it is Russia or Belarus, but it could be in other places. So there is a red flag because we've seen recent trading, but not necessarily trading of your company's items. So if you choose to engage with this customer, it's sort of do it at your own risk. It is possible that maybe that shipment they did to Russia was a one-time thing, and they won't do it again. However, if you're wrong, that's going to be a bad look for you, and then you have to call Vasu.
That's right. You're going to call Vasu.
Yeah, no, I think that's fair. I mean, again, right? Because like I said earlier, we're trying to comply with the government standards, and we're talking about the most aggressive regulator in the world. So it really is based on their expectations. And what's good about and what's fair about, I think, the way some of the regulators operate is they give you a list. They tell you exactly what they expect. BIS, the red flags indicators, there's literally on their website. There's
Singapore Customs too has on their website a list of red flags.
Yeah, everybody has these lists available, so you kind of know what you need to do. And unfortunately, the world we operate in now, and 10 years ago, we were doing this discussion with the FCPA. And now, 10 years from now, we're talking about sanctions. Maybe 10 years from now, we'll be talking about ESG. But it's a recurrent theme that kind of occurs in the way regulations and enforcement occurs. And so I think all of us have been on this journey some of us have been on this journey, others are joining this journey, and we'll go on this journey together for a very long time. But it's learning those best practices, understanding, and businesses, I think, the senior executives of companies now understand that, we can't bribe just because we're in some part of the world, we can't bribe anymore. It's because of the cases that were brought. And now I think it's, this is the cost of compliance. In order to be in this business, we're going to have to engage in compliance. So I think it's education from both sides and understanding the risks that you undertake when you do not follow the compliance guidelines that government share with you.
Now it's quite helpful. Like, Adam, you've made a contribution. You've thrown some red flags into the hat. Vasu has brought us to regulatory guide notes that are available. Now let's ask Hermanus. Hermanus, You know, in your experience, for us in the audience, we not only operate in one jurisdiction, we work with others in multiple jurisdictions. How have you internalized due diligence? Because we've heard ICP for 2 decades. You know, a lot of people think of it as a checklist, but we know here that ICP, or an internal compliance program or an export compliance program, ought to be focused from the lens of security. It's not a checklist, you require a whole company approach. How have you, in your experience, internalized due diligence practices?
Yeah, I would say that the first step for me is basically to translate that to what is actionable. So we talk about, okay, the objective is security, but what does it mean to me when I'm doing logistics or when I'm taking orders? So once we understand what the individual functions will have to do, then we will need to implement, as part of the ICP, implement appropriate processes and in particular the systems, because we talk about the updates that is happening so frequently. It's not possible for us to manually screen or review. So the systems will be very important. And of course, resources are never enough for us. So we need to make sure that whatever resource we have, they are competent in terms of trade compliance understanding. And as US regulations, they are extraterritorial. We need to, in Asia, we need to be very familiar with the foreign direct product rule if we manufacture in Asia, and see whether our product are subject to EIR or not. So that sort of translate from the security to what we can do to meet the security.
It sounds like you need to develop a RACI matrix. You need to have stakeholders in the company know what their tasks and responsibility are, and to map that out internally. So I'm not sure how many of you use a RACI matrix. Any of you are familiar with the RACI matrix? It's a project management concept, but very useful when it comes to internally doing what Hermanus was saying. We have about 14 minutes left on our panel, and I want to now transition to the other half of the coin. You have identified some of these red flags. It bothers you. It has been flagged to you. What are you going to do to address the red flags? Because there's only 4 things you can do to risk. You can either tolerate it, transfer it. You know the other 2 T's? It's okay. Absorb, manage, and ultimately transfer is what are the things that mostly you can do. So now that we have these red flags staring in front of us, how would you expect, Adam, a company to deal with it? We've heard of voluntary self-disclosure. Can you walk us through some of the practical benefits you see a recipient obtaining for having taken the effort to self-disclose?
Well, yeah, so in the first part, I guess going back to your original statement, a red flag is something that requires a deeper dive. It doesn't necessarily mean that there is a violation. So, but what you're asking now is if a company does do or investigates the red flags and identifies a violation. So a violation has occurred from our perspective, for a potential US violation for the Department of Commerce. We strongly recommend a voluntary self-disclosure. What we have seen quite often is that we will approach a company in the US and ask for additional information, and then they file the voluntary self-disclosure. But the timing is kind of off on that. You have to come to us before we come to you. It's not a good idea to hold on to this internal information. It's better to self-report, explain how you've found a problem, what steps you've taken to address it. And from our perspective, these are very strong mitigating factors, and a very, very high percentage of our voluntary self-disclosures end up with no penalty or a warning letter.
So now maybe let's flip it. Vasu, you probably have clients who want to voluntary self-disclose, and we know that in the region there are jurisdictions that don't necessarily have the same approach to voluntary self-disclosure as the US may. How do you advise your clients to approach voluntary self-disclosure? What has been your experience?
Yeah, I've never had a client who wants to voluntary self-disclose, just to be fair. Because nobody wants to go in and tell the US government, or just like your child doesn't want to tell you that they broke something in the house. Like, no, that's not, it hurts your reputation, it hurts your ability to get more cookies later, it's expensive, it's a long drawn out process. So, so all those things are real, and because we all live in the real world here. And the second piece of that, though, is that the US government, like they have in other spheres, is being very strategic about the encouragement for the voluntary self-disclosure. And what is that? If you don't self-disclose, they've figured out ways to ensure that that information can come to them. What are those things? One, you have Adam sitting here on a stage in Singapore, halfway around the world, going and visiting sites, talking to distributors, talking to manufacturers, looking for cases. They have journalists who are writing about these issues all the time. When I was a prosecutor, literally one of my cases, my boss left a newspaper on my desk and saying, figure out what happened here. So there's journalists that are out there, but also systemically, the US government has created the whistleblower programs. It started with the Dodd-Frank whistleblower provision for the SEC, immensely successful. And I think a lot of the regulators have now mimicked that model. And so now there is a VSD program for the Bureau of Industry and Security. It's different. It doesn't have a monetary reward, but they've created incentives that if you disclose information and against potentially a competitor, a customer, you can have almost like a credit against a further disclosure that'll be looked favorably upon, which is great. And then another thing that they're talking about is also financial institutions play a very large role in financing, involved in your transactions and loans. And there's a new guidance for financial institutions, which if they suspect transactions, they have now been encouraged to share information with the US government. So if you choose not to self-disclose, guess what? There's other ways that information can get to the US government. So the system is designed very systematically to ensure that that information gets to the government. So the default, and that's what I have to convince my clients, saying like, hey, listen, this is an issue, and you want to stay in this industry for a long time. You don't want your reputation to be hurt. You want to resolve this now. And so what we can do, and that's why we go back to the first question, show the government what we've done, show them this is an anomaly, show them how we are not going to allow this to happen in the future. And let's go in ourselves. And then I think, Adam, what is the declination rate if someone comes in themselves and shares information with the government?
I mean, it's probably over 90% of the VSDs receive
pretty good odds that if it did collaborate. But I think what Vasu says is interesting, right? Not only do you get the benefit of that 90% like approximate leniency, if you don't do that, that information is going to triangulate and it's going to come back and you're going to end up looking worse. Because it looks like your competitors may be the one to tip it off, your customers may be incentivized to whistleblow, and ultimately compliance is about doing the right thing when no one's watching, and it seems like the systems allow for that to take place.
And don't forget your banks too. Sorry.
And your banks, and the banks that have that positive obligations to report suspicious transaction activity. This maybe brings me to a question that I can feel some sympathy for. The question reads as follows. What if your customer is a trader? Now 30% of the audience here are in the logistics business. They are in the freight forwarding business. Singapore has 8,600,000 permits that Singapore processes, and that volumes are fairly large within Asia because of the country's entry port business, etc. So a lot of the people in this audience, their clients, etc., may be traders. So the question is this. What if your customer is a trader? How far down the chain should your due diligence go? And that is the question that I'm going to invite you all to discuss briefly. I liken this to be a vending machine situation where someone just says, I'm a vending machine, you press $1, you get a can of Coke. I don't care who presses the $1 button, but you get a can of Coke. Vending machines get abused. So if you want to become a vending machine, you may end up being abused, but I don't know. But I can feel the pain. Because if you find yourself being a trader, what do you do? How do you react, each of you? Whoever wants to go first, perhaps. Hermanas is reaching for the mic.
Okay.
Great.
Our practice is that we go all the way to the end user.
All the way to the end
We
user.
need to know.
Is that feasible for a trader who's making $30 or $100 per trade?
Okay, $30 again. We go back to the red flags, right? Whether your products are sensitive, whether the market that you serve is
Great.
sensitive. It depends on that. Of course, then as a trader, you have the benefit of reaching out to your manufacturer, who probably have better resources, better knowledge, better competency in terms of identifying red flags in the first place. So like I said, as a manufacturer, we do trace all the way to the end user. So if you're the trader, you go back one step up instead of one step down. And of course, you still have to do your due diligence to identify your own customers.
That's encouraging.
Yeah.
How does that sound to you, Adam? Are you happy?
Well, no. I mean, I think it depends. And there's some times where we've approached companies and they say, well, we don't want to tell the supplier who our customers are because they'll just cut us out of the business. We need to keep our customers, to ourselves. And I can understand that. And sometimes, again, when we go back to the microelectronics, these, low cost, ubiquitous, just, they're everywhere. And it would be impossible to say, tell us each and every end user of these 3 million, microelectronics that you're purchasing. So maybe a suggestion would be go to your distributor, give them an outreach and say, I want to make sure that you're aware of regulations, regional red flags, compliance, have them sign, some sort of statement, and you've essentially provided an outreach to your customer, and let them know that if you identify any violations, that you may be obligated to report them. You'll certainly cut them off as a customer, and in a way, you are compelling them to become a better representative of your products.
I think that's great. When you mentioned outreach, it made me to think about training, because long ago there was a case that I had prosecuted where the person who was the declarant agent, actually declared the end-use destination as Nampo. Nampo is a seaport in North Korea. And that immediately was a bit bizarre. Or not, I don't know how many of you know that Nampo is a seaport in North Korea, but if you had Googled Nampo, you will know that it's a country that you have probably sanctions as against that you can't deal with. So this then brings me to ask each of you, how important do you think it is for our friends here to invest in high-quality training when it comes to making sure that their supply chain is fortified? What are your thoughts? Maybe for Adam, tell us what are opportunities available for training that is available, and maybe for Hermanas, you can tell us what you are doing for training, and maybe for Vasu, what you can tell us whether or not training has been useful in your negotiations with the regulator to say, look here, we have a client who has done the training, and has that been mitigating? So in those orders, Adam first.
Yeah, no, I would say our agency does offer resources and some free training. It is sort of geared towards the U.S. compliance market because that's our stuff. But I think it's applicable to a lot of worldwide compliance best practices. So our website bis.doc.gov. There's a lot of resources that you can take a look at.
Awesome. So yes, you're right. I think the ethos presented in these help us with all our supply chain considerations. It's very country agnostic and threat focused. So thank you for reminding us of the resources on BIS. Hermanas, what have you noticed as ways that you are bringing about outreach or training for people in the industry?
With regards to training, I think it has been mentioned earlier, there's the general awareness training that applies to basically all employees. But there's also what I call targeted training that go more in depth into, for example, for the R&D staff on how to classify products, and you need to work with them on the process of how they can do that, because the R&D engineers, they are not really interested in trade compliance, so you have to find a way of encouraging them to classify. If it is logistics, then you talk about the Incoterms and the risk and the whatever. And of course, the sales order management team is another type of training that you need. So that's how you have two levels of training.
Okay, great. And Vasu, what has been your experience? Has it been a useful thing to point out to the regulator that your client is invested in training?
Yes, absolutely. I mean, there's no two ways around it. There was a case, again, in a different sphere, in the FCAPA context, where a executive was trained like 53 times over the course of like 2 years or 3 years, and the U.S. government listed that in its settlement documents about the credit it gave to the company, because despite the company's best efforts, despite telling this person he or she shouldn't do that, the individual engaged in this conduct, and the government used that as a indication to the marketplace, saying, hey, make sure you train your people, because when you do, we will give you a credit. I mean, it's one factor in the totality of the circumstances when you're talking about a settlement or negotiation, but it is a factor that, especially if it was addressed to the specific risk. So that's why I go back to the risk assessment. Training that is appropriate to the person's role.
Sure, and ultimately, if it's the person that has made the mistake, there's no reason why the company should take the fall for it, because the company can demonstrate that the culpability doesn't rely with the company, and that the individual was the one that should be found accountable because it has done all it could. I know that we have just literally hit the 60-minute mark. I'm looking to Dan to see whether we are on track for time. We are good. So I believe I have tried to get through as many of these questions in an aggregated way. If I haven't got to it, I apologize, but we will be available here to you as a resource throughout the day. I want to use this opportunity to thank my panelists for their wonderful and marvelous insights. Let's show them our appreciation with a round of applause. Gentlemen, it's been a privilege. We're going to get back to the affairs of the day. Thank you.